next matter to come before the court, NationStar Mortgage versus Brian Waisanen.
Thank you, Madam Chairman.
Yes.
My name is Susan.
Just one moment.
Oh,
Each party will have 15 minutes to present oral argument, and you may reserve up to 5 minutes for rebuttal. We've read the briefs. We're ready.
thank you very much. I'm a little nervous, so I jumped the gun here. But thank
That's
you.
quite all right. We're really not very mean here.
Thank you.
We get nervous as well.
My name is Susan Gray. I represent Brian and Jennifer Waisanen, who are the defendants in a foreclosure action filed by NationStar Mortgage. And we respectfully ask that the court reverse the decision of the trial court to grant summary judgment in favor of the plaintiff in that case, NationStar Mortgage. And if I forgot to say that, I reserve 5 minutes.
Very well.
Thank you. Your Honor, I represent a lot of people in foreclosure. I've been doing it since 1998. And I always, in my mind, want to emphasize that this case, as all those foreclosure cases, is about the rule of law versus the rule of the paper mill. It's about the house of cards created by the mortgage servicing industry to create financial transactions and then to foreclose on the interests of the borrowers who have essentially been used as the res, the financial transaction is their house is the thing that is the subject of the financial transaction. It's their house of cards, these assignments created after the fact with no connection to any reality having to do with constitutional interests and constitutional standing. And they place this against the real homes, the real houses, the real people, and our communities. And our communities have suffered. And we have lost a good neighbor, and having lost Brian Waisanen as a neighbor. He has been driven from his home by NationStar Mortgage, who had no standing in this case.
And you say it had no standing because?
It had no standing because at the Supreme Court, a post-Schwarzwald case, a Holden case, I think it's Deutsche Bank versus Holden, I can give you on this site, again emphasize that to have standing, you have to own the note. You have to be the one who gets hurt when the payment isn't made. And though it created a house of cards, it created a set of endorsements which was not quite complete because there was a gap in the endorsement chain. It created a set of assignments for an interest in the mortgage which was not quite complete. In fact, it had many errors, which did not lead to this plaintiff. But in addition, when we deposed the person from NationStar under 30b-5, that person admitted that NationStar did not own the note. That person admitted that NationStar did not own the mortgage. That person admitted that any proceeds would go to Everbank, somebody who was not a party to this case. That person admitted during his deposition that we being NationStar, assigned the mortgage to us because we were the ones who were going to proceed with the foreclosure. It's all about the creation of documents. It's not about real events. It's not about real transactions.
Well, to that point, are you suggesting that there is something illegal about this whole business of selling papers? Because it recognized in business.
I have no problem selling paper. That's what the UCC is all about. It's about commercial paper. It's about negotiability of, or transferability of negotiable instruments. It's about commerce. I'm talking about creating fake documents. I'm talking about using our wonderful laser scanners to give ourselves an interest in somebody else's home, or an interest in a security interest in somebody else's home that I don't actually have.
So what kind of fake documents are you specifically referring to here?
Well,
in
let's,
this case?
sure, let's look at the assignments. First of all, the assignments do not identify the loan. Well, let me go back to step one. Let me go back to the mortgage itself. The mortgage describes a security interest in 3 parcels of real estate. Mr. Waisanen purchased 5 parcels of real estate, but the lender, which was a non-bank mortgage lender, Shore Mortgage, only could give a loan on residential property, so it didn't even want those 3 other parcels. It apparently made a mistake when it created the mortgage and put the 3 wrong parcels in the mortgage, but no problem, we'll just add an addendum for the parcels that we want. And the evidence for that is that Mr. Waisanen and his wife testified that he initialed every piece of paper put in front of him. And that Exhibit A to the mortgage lists parcels totally inconsistent with the parcels in the body of the mortgage. So it starts there, but then it goes on. So now there's no question that he's defaulted. There's no question that Mr. Waisanen has defaulted. And the evidence of his affidavit, and because he's the sort of person who records his conversations, that's just the kind of person he is. we have the transcripts of his calls with NationStar, and he's.
Those weren't admitted by the court, were they?
I don't know why not. They were part of his affidavit.
I thought I read in the briefs that the court excluded them.
I don't think so, Your Honor.
Okay.
Or
we'll
I
certainly
missed
do that.
it. I wasn't aware of that. But even if his notes had been, his testimony is clear. I called them up. I wanted to smooth this transition. I wanted to be a good neighbor. I didn't want to leave an abandoned property. My neighbors didn't want to live next door to an abandoned property. So I wanted to stay until title transferred. That's what he was trying to do. And he could have easily done that with the entity who actually had an interest in the property. The entity who actually had an interest in the property probably would have been happy to accept a deed in lieu.
And that entity was?
Apparently Everbank. That's a testimony of the deponent from NationStar. And that is emphasized in our motion for summary judgment. Your Honor, I can give you the page numbers on that.
Oh, fine, thank you.
Okay.
Your assignment of error, I guess generally is the trial court erred in granting a summary judgment, but later on, you talk about in the statement of the issues presented, the trial court did not apply a summary judgment standard, but analyzed the case and formed conclusions as though the question were a motion to dismiss. And I will say that in reading the order of the court, it was not often clear whether we were in summary judgment land or whether there had been a trial and the court was finding facts.
Yes, Your Honor, that was one of my points in the brief, is that the court.
Well, you
weighed
raised that, but
evidence.
you didn't really, I'm not sure you developed it, but go ahead.
Well, that I think it was in, oh, let me find my brief, because I think that, think when I stated the issues, the first assignment of error is general, but then in the statement of issues presented on Roman numeral 5, I said it didn't, because the court didn't accurately apply this standard, first assignment of error to grant summary judgment, and then I said it analyzed the case and formed conclusions as though it were a motion to dismiss, it relied on hearsay, it
Weigh
failed,
the evidence.
right,
Okay.
and definitely weighed the evidence and always the inference in favor of NationStar. And so that was, yes, that was one of the grounds. And Your Honor, as part of that, the decision did appear to be almost about some other case. Sometimes there would be quotations from other cases, so they were about this case.
May I stop you just for a moment
Yeah.
to let you know, you had asked to reserve 5 minutes for rebuttal. You're at that time.
Okay, I'll just wait.
Okay.
Thank you very much.
Good morning, may it please the court. My name is John Cope. I represent the appellee NationStar Mortgage. There are 2 assignments of error before the court. The first is the Waisanen's state that the trial court erred on granting summary judgment. That's reviewed de novo. The other issue that they raised in their second assignment of error was that the trial court erred when it denied their motion to strike one of my client's affidavits. That's reviewed for an abuse of discretion. Thankfully, I think some of the issues have been a little bit simplified in this case since it was originally filed in the Court of Appeals. The property went to sheriff's sale without a stay. It was sold and sale confirmed. There's no appeal that's been filed from the confirmation. So I would respectfully submit to the court that, at least as to my client's mortgage claim, the appeal is moot at this stage because there's no further relief to be given in respect to the mortgage claim. That leaves the Waisanen's counterclaim, which included several causes of action. I would note for the court that in the briefing, the Waisanens had emphasized that they didn't mean to talk about the facts which they would have contended supported those claims because it was their position that the trial judge skipped over and analyzing the facts and instead seized upon a legal issue that my client hadn't raised in the summary judgment briefing, and that is that their counterclaims were preempted by the federal bankruptcy law. I think that's a mischaracterization of what the judge's decision actually was. I think when the court goes back and reviews the trial judge's decision, he very painstakingly, as we did in our briefing, the trial court below, stepped through the kind of piles of stuff that the Waisanens presented in the trial court record without any pinpoint accuracy and said, hey, I've looked through all of this. I've read the deposition transcripts. I've looked at these things that you say contend, support your claims, and they don't. On page 27 of the trial court's opinion, you'll find a paragraph that says, so I find that the Waisanens didn't meet their 56C burden. They didn't present me enough facts to show that they had a trial claim. And prior to that, and all the preceding pages prior to that, the court's going through and saying, okay, on these harassing phone calls you say were made, well, you didn't present evidence to me of harassing phone calls. You presented a list of dates and phone numbers, but you didn't tell me anything about what happened during those calls. And the judge even walked through it further, criticized their evidentiary presentation and said, I'm not even sure that you can get this in as non-hearsay because this guy's saying he made up this document long after the fact, so it wasn't a contemporaneous record of the phone calls that were made. So for the Waisanens in their appellant's brief to kind of give short shrift to the facts and say, well, we don't really have to dig into, and this court doesn't have to look at the factual analysis because the real error here was this legal thing about preemption. It just isn't true. It's not supported by the record. Now, the trial judge did say after he said, you didn't put in your 56C material to show that we have a triable claim, after he went through all of that, and this case has been a lot of paper. When they filed their summary judgment papers, they would say things like, look at NationStar's account history, and somewhere in there you'll find records of these harassing calls. It's like, well, I've got 20, 30 pages of account history. How am I supposed to pick through which ones this is? Or say, here's a Bates range of documents. That shows that they were being harassing and chasing them and trying to collect a debt that was discharged. But when you sat down and spent the hours to sift through all of that Bates range, you would suddenly realize that 80% of the stuff that's in the Bates range has nothing to do with what they're talking about. And then the tiny bit that might be close to related to it is kind of mischaracterized by adjectives and, saying that this is a sinister phone call and that sort of thing. And we painstakingly went through that in our briefing in the trial court below. And the judge painstakingly went through it all too and did the analysis on the facts, on the 56C standard.
There was a lot, wouldn't you agree that if you read the opinion, there's a lot of, I find this, that really sounded like it was an opinion that followed a trial to the court where credibility was being weighed, the evidence was being weighed. It was really not the kind of crisp opinion that we expect following a motion for summary judgment that would talk about, there remains a genuine issue of material fact as to this. There wasn't a lot of that in the opinion.
I would say, Your Honor, that he didn't address any credibility. There's nothing in there that says, I don't believe that person, but I do believe this person. The judge did have findings, but the findings were on things that were uncontested. And a lot of those things, those uncontested things, like he would say, okay, well, Everbank is the owner, and we don't contest Everbank as the owner, but that's legally irrelevant. So suddenly, it's still summary judgment, but that particular part of the case is getting disposed of with a legal application to undisputed facts, Your Honor. I think when you go back and look at the decision, there isn't a weighing of credibility. And the reason I was amazed. I got a 31-page or 32-page opinion in a foreclosure case. And I'll tell you the reason for that is because it was just lob after lob after lob of issues without actually driving down pinpoint citations to the judge or to me to show how what they're saying is supported by either the evidence or the law.
And as one of those lobs, I think I have a question. One of the issues that seemed to have been raised was that the mortgage as signed was missing the page that contained the legal description of the land that secured the mortgage. Now, am I correct in recognizing that that was one of the issues?
Yes, it was an issue raised, and I can explain it if you're interested.
Well, it was raised as an issue. Is it a dispositive issue?
No.
Why not?
It is not a dispositive issue for several reasons. First, my client, there were 5 parcels. The house sat on 2, and then there were 3 parcels behind. My client didn't go after the rear 3 parcels. Ultimately, it left that part out of the case. So this court's not reviewing a judgment about whether my client has the right to foreclose on those rear 3 parcels. So it's completely irrelevant at this stage. He admits he intended to mortgage the front 2 parcels, so there's that kind of practical aspect of it. A little bit more nuanced and detailed aspect of it. The mortgage, inside the mortgage itself, forget about the exhibit attached to it. It has vesting language. It says what property someone's going to get interest in. And this mortgage said, it's this street address plus these 3 parcels. That's in the body of the mortgage. What they were complaining about was that those 3 parcel numbers described in the body of the mortgage didn't have a meets and bounds description included in the exhibit. The case called Argent that's cited in our brief says it doesn't matter. You just have to give enough information to put people on notice that there's a mortgage in this particular property.
So the street address would be enough.
Street address is good for the front 2 parcels, which is what we actually foreclosed on ultimately. The parcel numbers in the body of the mortgage are good enough for the rear 3 parcels.
Thank you.
So, getting back to the summary judgment, I would respectfully submit that the appellants didn't carry their burden in this court. The trial judge made a determination. This is not, he didn't just, and let me back up a bit. So after he went through the factual analysis, he did realize, when he looked at one of the cases I cited for the proposition that not everything you send someone with a dollar amount on it after bankruptcy is an attempt to collect a debt. He cited the Ramirez case. He read that case from the proposition I offered it for. And then he read further and said, oh, this case also says that if you're complaining about discharge injunctions, you should be in bankruptcy court. So the judge did offer a new argument into the mix that I haven't raised in the briefs on that bankruptcy preemption argument. But that was his afterthought after the prior 3 or 4 or 5 pages were all about Mr. and Mrs. Waisanen, you didn't come into court and present me with any good 56C material, so you've got a tribal claim. So I didn't give that issue a tremendous amount of attention in my appellate brief, the preemption issue, because it wasn't really developed in the courts below, but it's not dispositive on this appeal. They would like it to be because they're trying to avoid the deficiency that they made in the trial court by not pointing out to the judge how they have claims. My client came in, we put forth all of our evidence. There were no credibility determinations. The trial judge said, well, I've looked at each letter that you've referred to, in these things. And yes, it refers to a dollar amount, but the law doesn't say that mortgagors or mortgagees can't tell you how much is due on the loan, and it doesn't mean that that's an attempt to collect a debt. It's information. It's giving you information about how much is owed. And if you'd like to keep your property, then you're going to have to come up with some way to pay it. Otherwise, they're allowed to come in and take it. This isn't a case about fraudulent documents and paper bills and stuff. My client has had put more paper into this case to establish its standing than you would see in most cases. We have deposition transcripts from my client's witness that talked about its doc track system. We've offered to present the original note to them several times in the course of discovery. They never asked to see it, so apparently it wasn't much of an issue for them. We presented an affidavit. The affidavit states it's on personal knowledge. Quite frankly, this case has a lot of paper volume to it, but the reason for it is because my client proved its case. They haven't demonstrated that the trial court erred in reviewing the facts. They didn't tell this court a single phone call or a single letter in their briefing that shows that there was some improper attempt to collect a debt after discharge. They didn't demonstrate to this court a campaign of torment or something. They referred to a barrage of calls, but guess what? There's no evidence in the record of a barrage of calls that the trial court considered was admissible. This court should affirm the summary judgment, should find that there was an abuse of discretion when it declined to strike the affidavit of my client. And we respectfully and hopefully will see that the court will help us end this case now rather than going back for further proceedings. Thank you, and I'll see the balance of my time.
Thank you. Counsel, you have a little less than 5 minutes.
Thank you. Your Honor, I would like to address the question from Judge Whitmore. I think it does matter that the assignment had no legal description because we don't know what was conveyed. That issue is not about whether it was 5 parcels or whether it was 2 parcels. It was what was conveyed at all. And those assignments, each of these assignments, refer to a loan, which is not the loan at issue in this case. Those assignments don't describe the lender as Shore Mortgage. The note says the lender is Shore Mortgage. The assignments say the lender is Mortgage Electronic Registration Systems, Inc., as nominee for Shore Mortgage. That MERS is not Shore Mortgage. MERS is not the lender. So that whole assignment chain does not describe a transfer of a mortgage interest from the lender. because it misdescribes the lender. And then what is being transferred? There's no legal
We
description.
see MERS as nominee in many, many foreclosure cases.
Yes.
Now, what is your particular challenge to that? You seem to be saying that as a matter of law, that is incorrect.
What is incorrect is that when the assignment is made, the assignment is a form that describes the loan, which is the subject of the mortgage. This particular assignment describes the loan as a loan payable to MERS. There is no loan payable to MERS. There is a mortgage to MERS, but there is no note to MERS. So the note itself, the obligation, which is said to be the basis for the security interest, is described as an obligation to MERS. You know, I think the things that happen in this case, if they happen in a normal contractual situation, we would view them very differently. The problem is we have such an incredible barrage of foreclosures that we get desensitized. We get desensitized. Our normal moral sensibilities, after a while, they just get numbed. And I think that often happens in these foreclosure cases. I would like to address some of the things raised by Mr. Koff. One is on page 16 of, not of my appellate brief, but on a motion for summary judgment. He says he doesn't know where these calls are, but on page 16 of the motion for summary judgment, I took the trouble to tell exactly where they were, I called them from the customer service notes. And these calls were particularly the subject of the deposition of the deponent, the representative from NationStar. He was asked about every one of these calls. And every one of these calls he said, I don't know, 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 I don't know anyway, I don't know. But when he filed his affidavit, he said, oh, we were just calling all those times to see if he wanted a loan modification. That is one of the reasons we moved to strike the affidavit of Edward Hine. He didn't know the purpose of those calls at the time of his deposition, and then he came up with a reason at the time of his affidavit. And I think I really just want to emphasize that it's certainly true that they have put more paper into this case to establish standing, but they haven't established standing because they have admitted that they are not the party who is injured. They are not the party who gets the money. They are not the party who gets the money when payment is made on the sale of the house. It doesn't go to NationStar, and he never said it did. It goes to Everbank. Everbank is the person who was hurt by the non-payment. Everbank is the person who benefited from getting the payment after foreclosure. Everbank was, if those facts are true, which are certainly the facts stated by NationStar, though that would be the one who should be the plaintiff, not NationStar.
You have reached the end of your time.
Thank you, Your Honor.
Thank you both for your presentations. The court will take the matter under advisement to issue a written opinion which will be sent to both parties, and do check the Supreme Court website as we post our decisions.
Okay, thank you, Your
Have a
Honor.
great day.